Couple of big lawsuits against the Obama administration on immigration and on health care. Joining us now, Oklahoma Attorney General Scott Pruitt. Thanks for being here.
Good to be with you, Brett.
Let's start talking about immigration. Your state has now joined the Texas-led lawsuit. Tell me how that happened and what it's about.
Well, it's now a 24-state coalition, so we're starting to see quite a large number of states, almost a majority of the states, that are very concerned about the president's action. And this case really, Brett, at its core, is going to set the trajectory for executive power for generations. We have a president who has said to Congress, because you've not acted the way that I think you should, I can act in your stead. We know that that's not allowed with our checks and balances in the Constitution. We know that it takes two branches of government to pass immigration laws. Congress should act. The president should act. There are many issues to be dealt with. But just because Congress hasn't or hasn't acted the way he thinks they should doesn't give him the power to do so. And so the case at its core is about that.
So, you know, I have former Vice President Dick Cheney on tonight, who was a fierce advocate of expanding executive power, a robust executive branch. For Republicans who've had that argument before, now this is the argument being made. Do you see a dichotomy there?
No, I think the Vice President is correct as it relates to foreign policy. I think that there are certain powers the executive branch has that matters to our safety or security that the courts have long recognized that they should act with great discretion. However, here, we know that the president has said on more than 22 occasions, in fact, in our research, he has said no less than 22 times, he does not have the power to do that which he did. So he is trying to use this, in my estimation, in a brazenly political way to threaten and intimidate Congress to act on immigration, and he's done so in violation of his oath. He's done so in violation of his Article 2 authority. He has a responsibility to take care to faithfully execute the laws. He tries to say he has prosecutorial discretion to do this, Brett. I use prosecutorial discretion every day in the Attorney General's office. You engage in that on a case-by-case basis. To think that you can engage in prosecutorial discretion with 5 million individuals and 24 field offices is not something that's possible.
Now, I've read, and we can't seem to get a straight answer on this, that he hasn't really signed an executive action or order per se.
That's correct.
What is the straight answer on this?
The straight answer is he has a series of memos that has been prepared for him by various components of the executive branch, and they're acting on that. Field offices and individuals in ICE is acting on the authority of those memos. There isn't an executive order per se.
Now, wouldn't there have to be?
No, I mean, I think that obviously, as far as the action the president has taken, we know what his instructions have been to those agencies. We know the violations that have occurred by virtue of those instructions, but it's not in the form of an executive order. I don't think it's necessary for a legal challenge. I think it's only necessary to provide a summary of what the president has done. But here, we don't have an executive order specifically.
It's extra Congress, outside of Congress.
The Office of Legal Counsel prepared a 20 to 30-page memo advising the president on what he needed to do in order to try to justify these actions. And so you just have a series of memos, a series of advisory type of documents that the president is now instructing his agency heads to engage in this action. But there is no executive order, but it doesn't, I don't think, affect the ability of the states to bring the action.
For the people, last one on this, for the people out there, including many Democrats who say, listen, the president tried to get Congress to act for a year and a half and there was no action on the House side, despite a passed a comprehensive bill on the Senate side. What do you say to that?
You know, I think that there are ideas that the president has proffered in these executive actions that may be good ideas. I mean, I happen to believe that more visas for those in the intellectual property or IT sector are very important. But we have something that controls the ability of the executive branch to act on its own. And here, the president has done that. It takes two branches to pass law, not one. And we need to respect that process. The states, you know this, it's not a quaint notion. This idea of state sovereignty was surrendered by the colonies when we entered into this grand experiment. And it was something that they expected representation to take place in Congress. When Congress doesn't act, you almost have preemption without representation, Brett, much like taxation without representation. And so the representative process is broke, and the executive branch can't fill that void just because they don't act, the legislative branch doesn't act the way they want them to.
Okay, Obamacare and the action that you're taking and the states are taking, joining another lawsuit. Explain that. Well,
Oklahoma, in August of 2012, we were the first state to challenge this action by the IRS when it passed the rule that said we're going to disregard the statute, issue subsidies through federal and state exchanges. As you know, Congress was very explicit in the Affordable Care Act. They used subsidies as an incentive to the states to set up healthcare exchanges. And when 34 states originally said no to that, the administration had a problem. Almost $700 billion of subsidies could not be issued. And so what happened is what has happened in many instances. The administration said that's okay, we'll fix it after the fact through administrative rule and agency action. And the IRS passed a rule disregarding the statute. That's what our lawsuit is about. What people don't understand, Brett, is that if there is no exchange in a state, no subsidies can be issued, but also no penalties can be assessed against businesses who fail to provide the type of health insurance that HHS requires. So fundamentally, the lawsuit is no state exchange, no subsidies, no subsidies, no penalties. So the very ability of the federal government to enforce the Affordable Care Act in 36 states now will fall substantially if the court agrees with what's happened at the lower court level. We won that case. The King case obviously is on its way up to the Supreme Court. We're supporting that. We're actually trying to bypass the 10th Circuit to join King to make sure that a state is represented in the argument before the Supreme Court. But it is a consequential case, and we'll know the outcome by June.
I mean, you go down that list, no subsidies, no credits, no penalties, but you win that case, and it's really no Obamacare.
I think that's a good summary. I think that's a good summary. Now, the motivation from a state perspective is not about the policy or the efficacy of the law. I don't believe that the law is a good law. I would not have voted for it if I was in Congress. But what is at the core here is, again, something that's more transcendent. It's rule of law, and that relates to that immigration issue as well. I mean, the results matter, but the process matters more. And we have checks and balances both vertically with federalism and horizontally between the branches. And we just have this attitude with agencies, Brett, at the federal level that says we exist to improve upon a statute. We exist to maybe change it if we don't like it in that way. And that's not how our process works. Agencies exist to administer the law, not make the law. And here we have an agency disregarding the plain meaning of the statute, the plain language of a statute, at the expense of the states and businesses and citizens.
Economist Jonathan Gruber, who some have called the architect of Obamacare, he refutes that up on Capitol Hill in testimony. But he also refutes the fact that he said on tape something that you're actually using in your lawsuit.
Yeah, we were the first plaintiff to actually take the video of Mr. Gruber saying to the states, you better set up these exchanges, because if you don't set up these exchanges, your citizens are going to be penalized by not receiving the subsidies. The Justice Department took this position, Brett, from the very beginning of our lawsuit, saying, oh, clearly Congress would not have intended that. That's not at all what the language means or meant during the debate. And then at the same time that the IRS was passing this rule in May of 2012 is when these videos were made and Mr. Gruber made those comments. It is clear that Congress intended that the subsidies only go through a state exchange. And the reason it's clear is because they had to incentivize the states to set up exchanges. And Congress did what they always do to incentivize that. They use money. And when 34 states said no initially, they had a problem. And then this administration took the course that they normally take. I have a pen and I have a phone, and instructed their agency heads to disregard the statute. That should matter, and that's what the lawsuit's about.
And despite the fact that Jonathan Gruber now says he's walking back that and didn't mean that, and Congress really meant that everybody should have subsidies, that doesn't affect where you are in this
Not
case.
at all. In fact, the federal judge in Oklahoma, actually, we filed that of record and said that his order is fulfilling the statutory language of the Affordable Care Act. The individual mandate was about taking the act down. It was about the authority of Congress to actually pass the law at its core. This is actually giving meaning and fulfillment to that which Congress put in the statute. And that's the reason I think, Brett, in many instances, I'm very encouraged that the court is taking this case up. It's a case about statutory construction. It's a very narrow case for the court. And I agree with you. If we are successful, and I pray that we are, it will lead to the collapse of the Affordable Care Act.
That will be something to watch, that case that should come up in the spring.
It's being argued in late February, early March, and we will know. Election day is coming in June.
Yeah. Attorney General Scott Pruitt, thanks so much for the time.
Thanks, Brett.